Hey, Anna, you are muted. How are you? Hi, Anna. I just tried to call you. Can you see me? Hello? I see that you have us live streaming on YouTube, and I do see the little dots at the bottom for us. Can you hear me? Hi, Miss Donna.
Can you turn off your microphone?
Yeah, hang on. Good morning.
Morning.
Happy Wednesday. Happy pre-hearing. Just to let you know, it looks like all parties are accounted for. Mr. McMillan, who do you represent?
Your Honor, I represent OPL along with Ms. Coleman and Ms. Golden.
Okay. Thank you. So I think the only party we don't have accounted for is CCAE. And I will wait a couple of minutes for Ms. Sir. Ms. Beatles requested to be excused. She had a conflict, and I granted that request. Just to let parties know, I did only include the attorneys for the parties in the pre-hearing. I see that there are some witnesses in the waiting room. They will not be admitted. They can listen on YouTube or any other representative that might not be a witness can listen on YouTube. I want to try to keep this as manageable as possible. So that's why I have decided to do it this way. I just received via email, hot off the press, from you, Ms. Hardy, a proposed order of presentation of witnesses and looks like I printed the same thing twice. So did you send me two things or one thing, Ms. Hardy?
Your Honor, I sent two. The second one added 2 witnesses for staff. I had received an update for staff. So the second document should be, let me make sure it's the correct one. Yes, it includes Mr. Chavez and Mr. Sidler.
Okay, so the second one is just a revision of the first one?
That's correct. It just added those 2 witnesses.
Okay. And then do you have another document for me that tells me what the proposed order of cross is and the proposed cross time?
Your Honor, as I stated in the proposed order, the parties don't expect to ask cross. They may have follow-up questions. So we hadn't prepared an order of cross, but I think it would be the same as the order listed for the presentation, which was based on the order of interventions.
Okay. Is that the order that they got admitted into the case or when they filed?
When they filed to intervene.
Okay. Because we had a few issues with some of the intervention requests, and some parties were admitted to the case after others. But if the parties have no objection to the proposed order of witnesses, you know, a lot of people are have your little mics off, so you can tell me let me let Mr. Stokel in. Okay, where's the cursor? Okay.
Ms. Hurst?
And it looked like Mr. Marks.
Good morning, Ms. Hurst. Good morning, parties. No objection to the order of witnesses or to what what SPS is saying about the order of examination, except that I would like to ensure that Sierra Club is included in the order if there is going to be any cross. We don't have a witness. We are not taking a position on the stipulation. Sierra Club remains an intervener in this case because we are very interested in matters that are related to what the company sought in its application. We don't have any concerns with how they're resolved in the stipulation, but wish to continue to be semi-active in this in case any matter was to arise at the hearing that went into one of the areas we were concerned with. We would want the ability to participate in cross-examination.
Okay, good point, Mr. Marks. Thank you. And I guess then what I would propose to do, unless there is some objection, is I would add the 3 non-stipulating parties after this in the order after Walmart. So after the stipulating parties by alphabetical order, and that would mean it would be CCAE and then Sierra Club and then WRA. Does anybody have an issue with that? That way, in the cross list, that would reserve your opportunity, Mr. Marks, and the other non-stipulating parties the opportunity to ask questions. The only proviso that I would make with that, or cautionary tale, is that part of what we're going to discuss here this morning has to do with exhibits. So Mr. Marks, and then if you want to communicate to Ms. Zur or Ms. Beatles, or if any party wants to do that, then you're going to need to download in the Dropbox any proposed exhibit that you might have. And I realize it's hard for you to speculate at this point, since you're a non-stipulating party and you're just reserving your right for cross, that you would have any exhibit that you would want to use. But what I'm trying to do is to organize a lot of exhibits on the front end and have them in the Dropbox available to all of the parties in preparation for them to work this weekend, if they would like to go through all those documents. I don't see any smiles about that, but so okay. Ms. Hardy, how do all the footnotes that you have about the party's availability correspond with how you believe that the flow of the hearing's going to go?
Generally, I think they do. I think most of the dates of unavailability for the interveners are after SPS would present its witnesses. I think within those dates, the interveners are willing to, and SPS is willing to have witnesses adjusted and move around to the extent necessary, but I think generally it should follow the flow of the hearing.
Okay. And I note on here that you have some witnesses that haven't formally filed testimony. That's correct?
That's correct, Your Honor. And I think that at least on SPS's behalf, we would only call them if Your Honor or a commissioner wanted to hear from them on bench responses.
Are you planning at this point, Ms. Hardy or any of the other parties planning on offering bench request responses as exhibits?
Your Honor, SPS is not. I think that a couple of the other parties are, and we are preparing a motion for admission of the exhibits that will list all of the exhibits the parties seek to admit, along with corrections and verification pages, in the hope that we would save time at the hearing by not having to go through questioning each witness if they adopt their testimony and have corrections. And with respect to the order of witnesses also, Your Honor, I think it really depends largely on questions from the bench.
And when do you propose that motion is going to be filed, Ms. Hardy?
Your Honor, I know that some of the parties are still determining whether they have corrections to their testimony, because we would want to include that in the motion, or we are including that. So I'm hopeful that we can get that filed today or tomorrow.
Okay. I would suggest to you that if you want some type of group consideration like that you file it by the close of business today. And I would encourage the other parties to make that determination, because obviously I'm willing to consider such a motion if it's going to be more efficient for us. If for example, the witness testimony that's going to be offered, the actual exhibit, is identified, for example, as SPS Exhibit 3, the testimony of Mr. Grant, and if it's his direct testimony, that exhibit include any corrections, additions, or deletions, and include any errata, corrections, additions, or deletions, so that we have one complete document that evidences that witness's testimony, along with the verification that's always attached to the testimony. So exhibits would have to be numbered, they have to be identified, and they have to contain all of the corrections, because I already have the link ready for you to put them in the Dropbox. Because at this point, normally I can do in some of the smaller hearings, I can just do an email to the parties and to the court reporter, but with the voluminous nature of the paper in this case, it's not possible. So we're going to do Dropbox, and we're going to need again to be able to have all of you populate the Dropbox, and then have it transferred so that you all have access to all the documents in the Dropbox, which at this point I'm assuming is probably going to be over 100 exhibits. Any speculation on that, Ms. Hardy? Probably over 100.
Let me pull up the motion. I think just glancing through it. I think it may not get to 100.
Okay.
I think that it's probably looking like 75, maybe.
Okay. And how does your motion deal with, for example, Mr. Grant, who filed more than one? Are you going to hold off on anybody that's we're actually going to see and let them do their testimonies? Or does your motion make any differentiation in stipulating witnesses and non-stipulating witnesses?
The motion does not, Your Honor. We were planning to include all of the testimonies in the motion. It does list, for example, for Mr. Grant, one exhibit is his direct, then his rebuttal, and then his stipulation testimony. So I think that's how the exhibits are listed right now for all of the parties.
Okay.
We're hoping to get all of them admitted without having to, just to save time, without having to question the stipulating testimony witnesses at the hearing.
And is there has there been any objection to this motion?
No, Your Honor, there hasn't.
Okay. I also, do any of the other parties have any planned motions that they find that they or procedural issues that they want to talk about before I talk about pending motions and procedural items that I have?
Madam Hearing Examiner, I just.
Ms. Drake.
Yes, ma'am. I just didn't want to lose sight. LES and FEA late yesterday filed two motions. One is to allow Mr. Gorman to adopt the testimonies of Ms. Alderson, since she is now on maternity leave and not able to attend the hearing. And the other motion is to withdraw two of Mr. Gorman's exhibits that were in his direct testimony that contain material designated by SPS as confidential.
And I did see both of those motions, and I'm going to talk about those in just a minute.
Okay, thank you.
Okay.
And I did send you this morning the Word versions of those motions in case you need those as well.
Okay. And I'll talk about those in a minute. Any other procedural matters that anybody has that I need to put on the list? Okay. I'm not hearing anybody. So, all right, Ms. Drake, I'll just go back to yours then. And was there any objection to allowing Mr. Gorman to adopt Ms. Alderson's testimony?
No objections from parties who responded to me. However, I did not hear back from staff or from WRA. So I am not sure. I can't say what their positions are on either of the two motions. All the other parties responded that they did not object.
Okay.
I heard
is this some?
I'm
Yeah.
sorry?
No, is this something that could have been dealt with weeks ago? I mean, did you not know she was going to go on maternity leave?
It
Surprise?
happened rather recently,
Okay.
unfortunately. So yes.
Okay. All right. Does anybody have an objection? Unmute yourself if you have an objection to this motion. If there's no objection, I'm going to grant that motion. So you're just going to need to make sure that, again, in keeping with our Dropbox and our potential granting of the SPS motion, that you have the exhibits have to be inclusive. So, I mean, people get that, right? I mean, we can't at the hearing, if we've already admitted the direct testimony so that we can actually get to the STIP testimony, you can't say, oh, well, I found a typo that I want to correct now, because that's, that's sort of the whole purpose of, of doing this ahead of time, and, and why it might not be a good idea for me to do it. But again, I'm willing to try to be as efficient as I can, and not have to take the time in the record to go through each and every exhibit. But like I say, that's kind of my worry about that. Okay, so that one's granted. And then you have the second motion about withdrawing attachments MPG 3 and 4 confidential from Mr. Gorman's Mr. Gorman's testimony, and the same, no objection, but you didn't hear from all the parties. Is that correct?
Correct.
Okay.
We did not hear from staff or WRA on that.
And if you withdraw MPG 3, which is 3 pages, and MPG 4, which is 1 page, is a testimony going to make sense?
I believe so. So if I could clarify, Mr. Gorman's direct testimony that was filed and served publicly includes public redacted versions of those 2 exhibits. And there are only a few little items that were actually redacted. So I think those exhibits with the redactions still make sense, and his testimony still makes sense. I don't believe that there were any portions of his actual testimony that included the confidential information. So I'm not asking to withdraw his testimony, simply those 2 confidential exhibits that were filed under seal and only served to those who had signed the confidentiality agreements. The rest of his testimony and all of his public exhibits would still stay intact as filed and served.
And therefore, based on what you just said, Ms. Drake, if the commission had questions about off-balance sheet debt for SPS, the witness would be able to answer those questions without referring to this exhibit.
In general, I think they would not be able to say, for example, quote the number, which is the redacted item in the in the version that is public. So to the extent you feel that that number that somebody, either you or a commissioner, may have questions regarding the actual number, that may be an issue. But otherwise, I believe Mr. Gorman could reply and answer generally, as he did in his testimony, without actually stating the confidential number.
Is there any objection from any of the parties with regard to this motion? Okay, no one's waving, no one's saying anything. I'm going to think about this and take this motion under advisement. Anything further, Ms. Drake, from LES or from you, Major Buchanan, for FEA?
No, ma'am. Thank you.
Very well. Then I have another motion that I got yesterday from the New Mexico Large Customer Group.
Yes,
Is that correct?
that's correct,
Mr.
Hearing Examiner Hurst.
Off. Okay.
correct.
And basic.
Sorry, did I cut you off?
Yeah, you were going to tell me something else?
Yeah, so in our motion, we also listed our responses to our conferral. We wanted to get the motion in front of you before this pre-hearing conference, so we went ahead and filed it yesterday, even though we hadn't heard from all the parties. I can update that COG told me they do not oppose the motion just after we filed it yesterday, which leaves staff, WRA, and CCAE as having no position on our motion. And the motion is similar to the one filed by Ms. Drake. I guess the wrinkle with ours is that there is redacted material in Mr. Higgins' actual testimony. And we would propose to file to admit his public version of the testimony, which would have that material redacted. But we're open to your thoughts on that if you don't think that will be sufficient.
Well, I got a couple of issues, but is anybody opposed to this motion? Not hearing or seeing anything. In going through the testimony filed on the 17th of May, Mr. Rushoff, in the commission's docket, Mr. Higgins doesn't have testimony in the public docket that was filed. I couldn't find it.
I was thinking that I was
The
looking yesterday.
The testimony that was filed on behalf of New Mexico Large Customer Group was the testimony of Justin Bieber. And there was a joint testimony from the Large Customer Group and Occidental of Mr. Garrett.
Checking on that at the moment.
So I'll let you check on that.
Hearing Examiner First, I'm on the PRC's docket, and I do see it.
Okay.
Admitted on May
And
17th.
I'm not saying that I couldn't have missed it, but
Yeah, we did file a direct testimony of Justin Bieber and the joint testimony with Occidental of David Garrett, but I do see the direct testimony and attachments of Kevin C. Higgins on behalf of the New Mexico Large Customer Group on there.
okay, I don't know I'm going to have enough bandwidth to do this, but let me try. And when you're looking, Mr. Rushoff, whose testimony is immediately above?
As I looked at it, Mr. Bieber's testimony is immediately above. And it looks like on the left column, the document ID is 1201902. If that helps. But those don't appear to be in order, so I'm not sure.
Yeah.
And then it's listed right above Mr. Gorman's testimony.
Okay, I will contact the docketing people. I'm pulling from a different screen, and I'm not pulling from the document ID screen.
Okay.
And so I guess to get back to the question then, do you believe that the testimony will make sense if I grant your motion?
Well, the issue discussed there was not necessarily part of the stipulation. So I guess for that purposes, it won't be necessary to examine the stipulation. And then Mr. Higgins' testimony redacted explains, his originally proposed adjustment and sort of the adjustment he proposes, but conceals some information that SPS claimed is confidential that sort of supports the adjustment. So I would say
Okay.
it would make sense the point he's getting to, but some of the justification I would say is redacted. So yes, I think it
Okay.
will be considered, and again isn't really information that's necessary to the stipulation we came to.
Okay. Okay, sir, I also will take your motion under advisement. At this point, Ms. Hardy, if the motions are granted to withdraw the confidential exhibits and or testimony, is SPS going to be able to does it plan to withdraw its request for confidential determination, or do you just still want me to rule on it on Monday?
No, Your Honor, I think if the motions are granted to withdraw the confidential material, we wouldn't need a ruling on our request for confidential treatment.
Okay, very well. Are there any other outstanding motions that I'm not aware or that I haven't mentioned that anybody knows of at this point? Okay, I'm not hearing any.
Your Honor, this is Katie Coleman for OPL. I believe we have a
Ms. Coleman.
pending. Hi. I think we have a pending Pro Hoc VJ admission motion for Mr. McMillan.
Okay.
It looks like it was served yesterday
Can you tell me when
morning. Yesterday morning.
Okay, so it may not be in here. Were there any objections?
My understanding is that Mr. McMillan conferred with the parties and there were no objections. We did not hear back from WRA.
Okay. Um, I don't see that you served me.
Okay, I will check on that.
Okay. I have the large customer group motion to withdraw in PDF and in Word. I have Miss Drake's and
just-
Major Buchanan's motion.
I'm just looking through the email service list and it looks like it went to Ms. Kippenbrock.
Yep.
I can forward this directly to you.
Yep, doesn't count if you send it to Anna.
Understood.
Gotta send it to me or okay. All right. Send it to me. I'll look at it. That's
Will do.
why I was surprised with Mr. McMillan. Not that we don't want you, Mr. McMillan.
Glad to hear
Yeah,
that,
I'll
Your
just take a look at that. Okay. All right. Any other procedural things like that we need to take care of? Going, no. Okay.
Ms. Hurst,
So we'll have
Ms. Hurst,
Mr. Marks.
not of the same order of magnitude, but can I would like to ask to be excused when I'm not present. I'm intending not to be present for several of the witnesses and to conserve resources for my client.
Okay. I don't really have an objection to the parties. If you have other reasons or other things that you have to do, you can be excused, Mr. Marks. But understand that you're waiving doing anything, you're waiving your ability to question, obviously, if you're not there.
Yes.
I'm not going to fit you back in later. And if we're discussing, anything procedural, you have to waive whatever you're not there for.
Yeah.
Okay.
Ms. Hurst, I understand whatever I'm not there for, we take as done by the people who are participating. And
Okay.
it may be that I'll be there for the entire time, but I wanted to ask in advance so it's not disrespectful to the tribunal if I wind up doing some other things and you don't see me on the screen.
Okay. And the tribunal appreciates that, Mr. Marks, on behalf of myself and the commission. So yes, that unless I hear some objection, which I don't see or hear, yes, sir, that your request is granted. Okay. So, I mean, I think we usually follow the same general format in these hearings. I mean, to the best of my knowledge, I actually have not. It's been a while since I attended somebody else's hearing, but we for things have changed a bit with the advent of the use of Zoom, but my notes have notes. But I think we pretty much follow the same type of format. And so what's going to happen is the people that are on the screen right now are going to be the people on the screen. And what's going to happen is that number one, you are responsible not only for yourself, but your witnesses' ability to participate clearly and concisely, and any, except for extraordinary circumstance, any preventable technical difficulty that could have been foreseen will be held against you. So you might want to check for, the witnesses' internet connection, their audio connection, etc., because witnesses will be required to have their video on, i.e. no telephone witness participation. Like I say, unless there's some extreme circumstance that occurs. I think that's, that's pretty much standard with what we all do. And just so that the screen is not clogged with so many faces that have us all on visual overload. I forget what the Zoom term is, but I want to just limit it to the attorneys. And those of you with multiple attorneys, if you are the handler for that particular witness, then I would prefer just to see you. That way I'm not going to have to determine if there's three of you, which one is actually is that your witness? Because I'm not going to allow tag teaming on a witness or a procedural ruling. You're going to have to dedicate one attorney to that particular witness.
Madam, hearing
And then Ms. Drake.
Yeah, I just wanted to clarify on that particular point. You're likely aware that FEA and LES are sharing two witnesses. And just to
Yes.
clarify for you and everyone in advance, I will present Mr. Gorman and Major Buchanan will present Mr. Walters. So we won't tag team. We'll each just present one of those witnesses.
Okay, thank you.
Sure.
So like I say, I think we're all pretty aware of, how the hearing is conducted. The attorneys will be on, and provide the link to your witness at the appropriate time. Otherwise, I would really ask you not to copy the link and provide it to other people. Again, we're going to have YouTube and people can listen on YouTube and have and be able to hear things. We've spoken a little bit about Dropbox, but but again, I think the having the PDF version of the exhibit that includes whose exhibit it is, have them numerically numbered, and again, that it is a full and complete document. Or, if you have something other than testimony, then you need to say SPS Exhibit 45, the SPS response to discovery request 543-2. Okay, so we just need to be specific in what we call the exhibit so that it's pretty easily identifiable, that it's complete. And also, I mean, those of you who have worked with me, you know that one of the, other than this fly that keeps biting me, one thing that's that I find a bit irritable is when the exhibit contains a color to represent something, and you've given me a black and white copy. So I really can't identify what the color line or bar, what the significance was of the distinction. So I would just remind you to make sure that if your exhibit's in color, that your PDF that you download is in color. Never say never, but everyone understands that it's best if we try to limit any corrections, additions, or deletions at the hearing. So I would appreciate if we keep those, if they're non-existent, or kept to a minimum. I also, again, as I think I referenced to Mr. Mark, you know, you don't know what questions I might ask or one of the commissioners might ask, and it might lead you to believe that in your opportunity to ask questions or redirect your witness, that you need an exhibit. I understand that, you know, that those kind of things are going to happen. Again, I would you know, just encourage people to try to keep those to a minimum. Also, with regard to Dropbox, I'd like each of the parties to prepare the list of what their exhibits are and include that list as a document in the Dropbox. So not necessary, Mr. Marks, to say Sierra Club doesn't have any exhibits if you don't. But for those of you who do, for example, you know, just put.
Good afternoon, Katie. My name is Pat Weapon, and I'm the firm-wide records manager.
Okay, I don't know who that was, but if you know, if you have 3 exhibits, you know, that you can tell me that. You can just say, okay, party X has 3 exhibits, 1, 2, 3, here's what they're. That way I have a list and can check against what is actually in the Dropbox before I disseminate it, allow access to everybody. Okay. Just, you know, I'm really trying to obviate the need for me to issue a pre-hearing order. So I rely on the professionalism of everyone here today, especially those who have been doing this for a while. You know, the commission doesn't allow friendly cross. Please don't do it. I realize this is an uncontested stipulation, but if there are questions that are being asked, for example, of SPS witness, you know, I really don't want to hear one of the other parties come in and try to offer friendly cross to, you know, rehabilitate or try to add some type of impermissible information to support the step. So we know what it is. We've seen it. Please don't do it. Okay, I've already told you about the witnesses. I've told you about the Zoom. And should there be any exhibit that is not an exhibit that has already been disseminated to the parties, please identify that. Again, I don't know that there's gonna be any, just because it's an uncontested stipulation. But it would be good rather than to just plop it in the Dropbox if the parties let whoever they plan to use this exhibit to examine, no. I mean, you should let everyone know, hey, I've got this new exhibit. But anyway, again, not real applicable here. Just want to try to cover all of my bases. And I guess just because there's a few of us on here, if you have something to say, or if you have an objection, for example, during the course of the hearing, please just, identify yourself first. I have an objection. This is so-and-so, and then wait for me to find you on the little picture screen. And so that I can totally be focused on what you have to say. I am still contemplating, and we'll think about it with the proposed order of witnesses, what logically makes sense. To me, for example, if and I'm open to suggestion briefly on this point, but for example, if I or one of the commissioners has questions for a witness who has only filed direct testimony, what logically or more cohesively in the presentation of the course of the case, does it make sense to identify that witness first in the order and ask the questions of that witness prior to the presentation that's being proposed here? And I'm not trying to make it unduly complicated. Really, I'm not. But I'm just trying to find a way that makes sense, that like I say, if as you know, not all of the witnesses for every party testified in direct rebuttal and stipulation. So for example, someone like the ROE witnesses, I don't think it's going to make a difference, because the ROE witnesses generally testified in either 2 or 3 of the testimonies. So I don't see that as a problem, but again, I'm trying to get to some of those witnesses, especially company witnesses, who only filed testimony, but didn't testimony prior to the stipulation testimony. Thoughts?
Your Honor, or does Mr. Du Bois want to address this?
Good morning, Your Honor. Will Du Bois for SPS. If I may respond a bit to your question.
Yes, sir.
Thank you. For its part in listing the order of its witnesses, SPS did attempt to group witnesses by topic, but I would also say that because the parties are not going to be examining one another's witnesses in the absence of questions from the bench that raise issues, at least for SPS's part, I can say that if there is a order of witnesses or guidance on when Your Honor or commissioners would like to have witnesses appear within certain parameters, we're happy to change the order or timing of when our witnesses would be available.
Okay.
And Your Honor, if it happens to be known that there are any witnesses for whom there will not be questions, if that is known, we would of course appreciate if or when that guidance can be given so we can let people off the hook.
Excellent segue, Mr. Du Bois. I appreciate that. Anything further?
Thank you, Your Honor.
So for example, I have questions for Mr. Berger. SPS witness Berger. I believe no, that's what happens when lists have lists. Okay. So there are also questions for Mr. Shipman, SPS witness Shipman. It is my understanding that only Ms. Crane filed testimony on behalf of the Attorney General. Is that correct, Mr. Elliott?
In support of the stipulation, she
Yes.
provided. Is that what you mean? We also had Mr. Gigax and Mr. Cahall submit
Yes.
direct.
Yes, and I'm just referring to stipulation testimony, and I do know that Dr. Gigax and Mr. Cahall filed pre-stip testimony. But as far as stip testimony, just Ms. Crane, correct? Okay, yes, sir.
Yes.
Okay. Mr. Cahal needs to be available for questions from the bench.
Yes. We've provided dates of availability and non-availability.
Excellent. Thank you, sir. And for OPL and the large customer group, it's my understanding large customer group is Mr. Higgins. And for Occidental is Mr. Pollock. Is that correct, Ms. Coleman?
Yes, that's correct.
And Ms. Drake and Major Buchanan, is that correct? Gotta unmute yourself, Major.
I'm sorry, Your Honor. Were you asking about our witnesses? I thought that
I'm
was-
just the stip witness. It for no, Pollock and no, I'm sorry, wrong parties.
Yeah.
Is that correct for yes for Oxy and yes for the large customer group?
That's correct. Kevin Higgins.
Mr. Rushoff. Okay, very well.
Yes. And we, just to
okay.
clarify, we also had direct testimony for Justin Bieber that at this point, we're not planning to have appear at the hearing, but if you would like him to appear, please let us know.
Yes, Mr. Bieber and Mr. Garrett both need to be available for questions from the bench.
Okay, thank you.
And for FEA, LES, we already have all three witnesses filed testimony, and it's just Ms. Alderson. There will be questions for Mr. Gorman and for Mr. Walters. And I believe Mr. Bartel you represent Walmart?
That is correct. Yes.
And you had an answer to a bench request, a Mr. Cronauer?
Yes. The company decided Mr. Cronauer was more qualified to respond to the specific inquiries than Mr. Chris. So that's why he responded to that with supporting testimony.
Very well. And there may be questions with regard to that response.
Okay.
All right. Okay, so I think I have identified some of the witnesses who, I think I've identified all of the witnesses at this juncture. Who haven't filed stip testimony, that there may be questions, but I'm just going to put out there that, you know, you never know if a question comes up, and especially we all know that witnesses defer questions to other witnesses. So if you're deferring, if your witness defers to somebody that we haven't necessarily identified today as somebody that there's going to be questions for, then obviously you're going to have your witnesses available to answer those questions. If if necessary. So, I mean, I can't at this point. I mean, I think everybody has a pretty good idea of which of the witnesses are not going to be, that there's not going to be questions for. But again, I cannot excuse all of the witnesses today. Just can't do it. I think it'll become more clear as we go through, and especially if I get that if I have our group testimonial exhibit, that's going to assist in completing our record. But again, at this point, I can't, or I don't know that I can't, but I won't. I'm not going to excuse any particular witness today. Is
Your
there
Honor.
anything else, Ms. Hardy?
Apologies. Your Honor, would it be helpful if we provided an updated list of the witnesses that includes some of the ones that you mentioned in case they have dates of unavailability?
Absolutely.
Okay. We'll do that, Your Honor.
Very well. I appreciate that. Want to try to work with everybody's schedule and, looking optimistically, as events have unfolded in this case, you all have a stipulation, you all have reached an agreement on a multitude of issues, or have decided that some of those issues aren't as important as maybe you thought. And the whole give and take of the settlement process, you've reached a stipulation, you filed testimony, and that's obviously has cut down on the amount of examination that's going to be necessary. I'm optimistically thinking that we're not going to need the 2 weeks that we have allocated for this hearing. I'm also optimistically thinking that we can hopefully get this done in a week, and or less, depending. And we will endeavor to be as efficient as we can in providing our full, fair, and complete record resolutions in this case. So, anybody have anything else that they'd like to discuss, or any questions on what I believe that the appropriate procedure is going to be for conducting our hearing? No. As everybody knows, we do the same things that we always do. We're going to start at 9. We'll try to take a break in the morning, 1 in the afternoon, an hour or so for lunch. And if anybody has, anything procedural, please make sure you, email me, call me, whatever you think is appropriate. And if we don't have anything else that we need to discuss, I will expect that motion by the close of business today. And I also will expect that parties will have dropped their, unless there's some, catastrophic reason why, will have put their exhibits, including their exhibit list, in the Dropbox by close of business tomorrow. Does anybody see that as a problem? Those two deadlines? No one's saying anything. Okay, very well. I appreciate your time, your promptness. I look forward to our hearing on Monday, beginning at 9. And if there's nothing further, then we are recessed until Monday at 9 a.m.